You're sitting in the back of a police car, handcuffs tight, the door closes. That heavy, final sound. The officer leans in and says words you've heard 1,000 times. You have the right to remain silent. Anything you say can and will be used against you in a court of law. You have the right to an attorney. You nod. Everyone knows this. It's in every movie, every TV show, every crime drama since the 1970s. But here's the part nobody tells you. For over 170 years, from 1789 until 1966, those rights did not exist. Not on paper, not in practice. You could be interrogated in a back room for hours with no lawyer, no warning, no way out. And the reason you have them today starts with a 23-year-old man who never finished the 9th grade and who didn't know his own rights were about to change the law forever. You assume Miranda rights are ancient, baked into the Constitution from the beginning, that the Founding Fathers somehow foresaw police interrogations and built protections against them. They didn't. The Fifth Amendment says no person shall be compelled in any criminal case to be a witness against himself. For 170 years, courts interpreted that phrase narrowly. It applied inside a courtroom, not inside an interrogation room. Police could question you for 12 hours straight, and as long as they didn't torture you in ways that left visible marks, any confession they got was admissible. His name was Ernesto Arturo Miranda, 23 years old, never finished 9th grade. On March 13, 1963, the Phoenix Police Department arrested him for the kidnapping and rape of an 18-year-old woman. 2 detectives took him into a separate room. No lawyer, no warning, just questions, for 2 hours straight. By the end, Ernesto Miranda had signed a written confession, and at the top of that confession, in typed letters, were these exact words. This statement has been made voluntarily and of my own free will, with full knowledge of my legal rights, understanding any statement I make may be used against me. Full knowledge of my legal rights. Nobody had told him what those rights were. Nobody mentioned a lawyer. Nobody mentioned silence. His lawyers, John Flynn and John Frank, took the case to the Supreme Court of the United States. But Miranda's case wasn't the only one. 3 other men, arrested in New York, Kansas City, and Los Angeles, had confessed the same way. No lawyer, no warning. One of them, Roy Stewart, was held for 5 days, interrogated 9 times. He'd never finished 6th grade, and based on what he said in that room, he was sentenced to die. The Supreme Court combined all 4 cases into one. This wasn't about saving one man from Phoenix, it was about a system. Their argument was precise. A confession only means something if the person confessing actually knows they have the right not to. On June 13, 1966, the Supreme Court ruled 5-4. Chief Justice Earl Warren wrote the majority opinion, and the ruling was direct. You have the right to remain silent. Anything you say can and will be used against you in a court of law. You have the right to an attorney. If you cannot afford an attorney, one will be appointed for you. Warren had read the actual interrogation manuals police used at the time, pages that taught officers exactly how to isolate a suspect, project total certainty of his guilt, and wear down resistance without ever raising a hand. None of it left a mark. All of it worked. 5 justices had just changed American policing forever. 4 believed they'd gone too far. Justice John Marshall Harlan warned it was, in his words, poor constitutional law, one that would carry consequences for the country no one could yet measure. Justice Byron White went further. He warned this ruling would send dangerous people back onto the street because without a confession pinning down what actually happened, some cases would simply fall apart in court. They weren't wrong to worry about that part. The case was named Miranda versus Arizona, and it immediately threw out Ernesto Miranda's confession. Here is where the story stops being a legal lesson and starts being something stranger. Miranda was retried, without the confession. Twyla Hoffman was Miranda's common-law wife. After his arrest, she visited him in jail, and Miranda, the man whose case had just forced the Supreme Court to rewrite the rules of interrogation, told her everything. Hoffman testified in court. Her account was specific, her account was detailed, and it was enough. He was convicted anyway. The rights named after him couldn't save him from that. He was paroled in 1972. 2 years later, he was arrested again, drug and firearm charges this time. The charges were dropped, but the man whose name was now attached to the most famous warning in American law kept ending up on the wrong side of it. After his release, Miranda lived in Phoenix. He sold autographed Miranda warning cards for $1.50 each to lawyers, prosecutors, and police at the Maricopa County Courthouse. He called himself a busy salesman with a fast-moving commodity. On January 31, 1976, he was stabbed in a fight at a bar in Phoenix. He died before an ambulance arrived. When police arrested a suspect in Miranda's killing, an officer pulled out a small card, printed in English on one side, Spanish on the other, and began to read. "You have the right to remain silent." The very words Miranda had given the country, read to the man accused of ending his life. Today, versions of the Miranda warning are read in over 100 countries. A ruling about one man in Phoenix became the global standard for how governments must treat the people they arrest. Here is what most people miss about Miranda versus Arizona. The Supreme Court didn't rule to help Ernesto Miranda. They ruled because the legal system had a problem it couldn't ignore. Confessions were being produced in rooms the public never saw, under conditions nobody could verify, from people who didn't know they could say nothing at all. The law isn't sentimental. It doesn't protect people because they deserve it. It protects processes, because without reliable processes, no verdict means anything. The Miranda warning is not proof that the law cares about you. It's proof that the law cares about itself. Ernesto Miranda never really understood what he'd started. He just wanted to go home that day in 1963. He talked instead. And in doing so, he forced the most powerful legal system in the world to write down the words it had never bothered to say out loud. The next time you hear those words in a movie, remember, they weren't written for the screen. They were written because one 23-year-old, alone in a room, kept talking. The law doesn't remember who gave it its name. It just keeps saying the words. Every law you follow started somewhere strange. Subscribe to Lex Origins, new videos every week.